the Kansas Court of Appeals. We're meeting by Zoom. We thank you for your consideration and your willingness to do that with us this morning. My name is Catherine Gardner, and I'll be serving as the presiding judge today, so I'll be keeping time. I believe each of our three cases is set for 15 minutes, and so I will let the appellant let me know if you would like some time for rebuttal. And with that, I'll introduce our panel. I'm happy to be seated today with Judge Stephen Hill and with Judge Leslie Isherwood. So we have three cases. We'll go ahead and call the first case. And counsel, I'd like your appearances, please. In 123782, Gary A. Culliss, appellant versus Brian R. Culliss as trustee of the Julia A. Culliss Trust, appellee. For the appellant, please.
May it please the court, Michael Orong on behalf of the appellant in this matter, Gary Culliss.
Thank you, counsel.
And Your Honor, may it please the court, Jeff King appearing on behalf of the appellee, Brian Culliss, as trustee of the Julia A. Culliss Trust.
Thank you, Mr. King. Mr. Ong, you may proceed. Would you like any rebuttal time?
Hey, Your Honor, if I could reserve, I'll take 8 minutes at the beginning and reserve the remaining 7.
Okay, you may proceed.
Please, court, this case really concerns whether a trustee / fiduciary has the power under Kansas law to substitute his desired distribution of a trust fund account over the wishes and the stated intentions of the grantor herself. We contend that the Kansas Trust Code, well, we contend two things. Number one, the trust document is clear on itself. Trust assets are to be divided equally between the two sons. What happened here basically triggers the portion of the trust code referred to as the duty of loyalty, 58A 802B, where it says where a fiduciary enters into a self-dealing transaction, uses trust funds or allocates them for the personal benefit of the fiduciary, that activity is subject to being voided by the harmed beneficiary. In this case, our client, who was a 50% beneficiary of the trust, within 24 hours of being notified that the fiduciary intended to allocate the real estate solely to himself, objected to that and said, in essence, our mother intended this to be this asset to be shared equally by us, and the trust document provides equal distribution. And I desire to co-own this property with you in accordance with the trust terms. And that's what 58A 802B, the duty of loyalty, says. A trustee or any fiduciary for that matter can't use trust assets for personal benefit. And the Kansas Supreme Court just in 2020 in the Roan case stated that the duty of loyalty, such a fundamental duty of the duty of loyalty, cannot be waived. It can't be waived by a trust document. It's that fundamental. The very essence of being a fiduciary is you act for the best interest of the trust beneficiaries and not for your own account or your own benefit.
So, Mr. Ong, let me ask you then, if we agree with you that that case does say that you cannot waive the duty of loyalty, are you saying that even though there was a financially even or equitable distribution regarding the lake house here as between the two beneficiaries, that nonetheless the beneficiary has veto power because of a statutory duty of loyalty?
That's what a 802, that's what the duty of loyalty says. It says that it is a basically voidable transfer by the harmed beneficiary absent agreement. And again, just thinking about this under under Kansas being a farm place, being a farm state, or frankly, any state with any asset, if we allow fiduciaries over the objection of the other beneficiaries to say, I'll take the family farm, it's been in the family since the 1880s, and you get the certificate of deposit on bank down the street, you know, for their personal benefit, or thinking a fiduciary maybe has more knowledge of the trust assets than a affected beneficiary might say, I'm going to take the securities, you're going to get the land, only to find out later that that land was, you know, in the path of development or close to a toxic site. This power can be used to benefit a fiduciary or to take an advantage of a unwitting beneficiary. It would really toss the notion of fiduciary duty into chaos in the state. And again, the person who had the ability to provide otherwise was the grantor. And actually, Julia Culliss could have made other provisions for how this property was handled. The property was deeded, transfer death deed at the same day the trust was known. So this was what we call in the business an inception asset. It was there from the very beginning. As our brief talked about, there could have been a right of first refusal given. There could have been a process for beneficiaries to submit basically sealed type of deeds. There could have been a discount granted to one of the beneficiaries. She did none of those. She just said divide equally and distribute outright. And that's significant. It's her plan. And when we allow fiduciaries to substitute their wishes for the trust document, that's where we really could get into, frankly, chaos if we allow fiduciaries this kind of green light to exercise this power. It becomes their estate plan, not their mother's, and that's the danger here. We cited the court relied on this, what we would call a boilerplate provision, the non-proratic distribution language in the trust, as being language that trumps the duty of loyalty. And as our brief talked about, we talked about the Kansas Supreme Court case, the McGinley case, and also the Shorts v. Barker case. That's an unpublished Court of Appeals case, but the Supreme Court in the Roan case relied on the reasoning in the Shorts v. Barker case to say these fundamental fiduciary duties can only be waived by express exercise of that power by the grantor. And you see both when it's done and not done. And the Supreme Court recognized in the McGinley case that a trustee that the duty was overrun by an express written document by the grantor. And the Shorts v. Barker case said, no, we can't stretch boilerplate language to waive a fundamental right. And I think those are the guiding principles, statutory 802B, and then the Roan McGinley starts type of reasoning. Well, just in the very brief time I have left, the other issue beyond that is the fee issue here. And we think the court, frankly, abused its discretion. Obviously, these are significant and weighty kind of legal issues brought in good faith by the appellant. And for the court to say, no, we're going to award all the fees against the appellant. There's not a on-point trust case we saw on this, but in the probate world, which is very analogous, the estate of Pesh case says, when a fiduciary is acting for their own self-benefit, that's not in the best interest of the trust, and that's not in the best interest of the estate. It's for their personal gain, and charging those fees against the trust is not appropriate. And so we think resolving the issue of the duty of loyalty, frankly, resolves the issue of the trustee fees. Thank you.
Thank you, Mr. Ohm. Mr. King, you may proceed.
Thank you, Your Honor. May it please the court, Jeff King on behalf of the appellee. Would like to start with actually a statement that opposing counsel made. and I'm quoting it as best as I can, said, quote, Julia Culliss could make other provisions for distributing trust assets if she wished, end of quote. The good thing here is she actually did. And she did that through Article 5 in her trust. And Article 5 in the trust reads specifically, quote, except where there are directed dispositions of specific assets, trustee may make any distribution in cash or in kind, including non-proratic in-kind distributions or a combination thereof, end quote. All the parties in this case concede that there were no directed dispositions of specific assets. So what Julia Culliss did through her trust is say, I am going to empower my son, Brian Culliss, as trustee to make non-prorated distributions as he sees fit to give equal value of assets to both he and his brother. If I want to limit his ability to do that in any way, I will make specific directed dispositions of specific assets. And then she chose not to do so. So what Brian Culliss in his role as trustee has been doing, Mr. Ong and I agree on one thing. The trustee cannot act over the specific wishes of the grantor as articulated in her trust document. Rather, in this case, Brian Culliss has acted precisely according to the wishes of the grantor as articulated in the trust document through trust provision Article 5.
So, Mr. King, let me ask you this. Is it your position that as long as the trustee complies with the express terms of the trust, that satisfies the duty of loyalty, the statutory duty?
It absolutely, Your Honor. In fact, if you look at 802B1, the fundamental statutory provision on duty of loyalty cited by Mr. Ong, that actually authorizes a transaction that would otherwise be self-dealing if, quote, the transaction was authorized by the terms of the trust, end quote. Here we have a specific provision of the trust authorizing the transaction. So even if this transaction would have been self-dealing without the Article 5 provision, Article 5 and 802B1 specifically authorizes that action.
Thank you.
And Your Honor, I think one distinction that is important to make on this, throughout the briefing, appellant states that the district court somehow waived the duty of loyalty. Actually, Your Honor, the district court did nothing of the sort. It specifically recognized the application of the principles of 802 and the duty of loyalty to this case. But what the court did was find that the actions, for the reasons that I previously stated, are actually consistent with the duty of loyalty. And the district court made no finding that there was a boilerplate provision of any sort here, that this non-pro-rata provision, vital in this case, is somehow boilerplate. But even if the court had made that finding, whether this provision is boilerplate or not is a red herring. It's absolutely irrelevant to the analysis. And to see that, we need look no further than the case relied on by appellant, the McGinley case. At page 438 of that opinion, the Kansas Supreme Court relies on the very type of provisions that Mr. Ong has described as boilerplate in order to authorize the trustee to take an action that it deemed would have otherwise been contrary to the Prudent Investor Act. So the court here didn't look at trust provisions, the Supreme Court McGinley, and say, well, this one's boilerplate, so it doesn't apply. But this one isn't boilerplate, so it does. It looked at the words of the document, the intent of the grantor as expressed by the words of the document, and then relied on those to say, yes, under black letter Kansas law, you are allowed to, in the trust, look at issues, through the language of the trust to circumvent what would otherwise be a controlling statutory duty, whether the language is boilerplate or not. Your Honor, furthermore, the right of non-pro-rata distribution was actually conceded by appellant in his petition that started this case. The initial petition by the appellant asked for a non-pro-rata distribution of the property, in question, the lake property, but rather they asked for the non-prorated distribution to him. The appellant is conceding that no non-prorated distribution of the property is allowed. He just doesn't like how that non-prorated distribution is done. Effectively, if the court sides with the appellant in this case, we are creating a rule in Kansas that when you have a trustee beneficiary, any of the other beneficiaries have essentially veto power over the exercise of non-prorated distribution, even if the grantor specifically authorized that distribution. So the theory that is being articulated by appellant here doesn't give Brian Culliss as trustee the ability to circumvent the wishes of the grantor. It actually would give the beneficiary non-trustee, Gary Culliss, the ability to circumvent the wishes of the grantor and get essentially veto power over a non-prorated distribution. In addition to, Your Honor, I will turn to the second issue that was brought up in the petition, was the idea that the district court abused its discretion in finding the appraisal of the appraiser hired by the trustee, setting an appraised value of the lake property of $177,000, agreeing to that value as an abuse of discretion. As I think appellant almost concedes by barely addressing the point, substantial evidence supported the $177,000 appraisal. We had an appraiser that testified, that did an appraisal twice, that came to the property, that noted that the depth of water in the property, the existence of the current docks would not allow the property to efficiently be split in two. Notice the water level limited the ability of boats to get to an alternate dock that might be built on the property. Notice the condition of the property without any contrary appraiser appearing to testify against that value. The really only argument made by appellant against the assessment of the $177,000 value is that the appellant was willing to pay more, was willing to pay $226,000 for this property, and saying because the appellant would pay more, that must be fair market value. There is nothing in Kansas case law, nothing in the trust context or any other context that set fair market value as what a litigant will pay. If indeed that were the position that this court would take, that we wanted to shift Kansas law in that direction, then basically anytime properties are distributed, it would become a bidding war where the highest bidder, the beneficiary with the most money, would get mom or dad's property. I mean, we could see scenarios where mom's wedding ring is appraised at $2,000 and someone says, I'll pay $5,000 for mom's wedding ring. And then all of a sudden, the beneficiary with the most money gets to decide which of mom and dad's property they get, contrary to the wishes that are set forth by the beneficiary. The reference to the Prudent Investor Act is an absolute red herring that deals with investing of money, not of distribution of assets. There is no self-dealing here, as we've discussed, but even were there, only if there is imprudent investing would the Prudent Investor Act come into play. The other issue that was raised in the briefs deals with the allocation of fees. And the allocation of fees is authorized specifically by the trust and under 58A 1004 of the Kansas Uniform Trust Code. There is no question here that the court possesses the authority to assess fees under that provision of 58A 1004. It clearly provides that the court may allocate fees, quote, to any party to be paid by another party or from the trust. Here, the court has allocated that the fees be paid by another party, appellant Gary Culliss, clearly within the auspices 58-1004. So the only question is, did the district court abuse its discretion in allocating these fees? Your Honor, there was no question of reasonableness of the fees. That was not made at issue, whether the too many hours billed, the hourly rate was inappropriate. No question of reasonableness was raised. The only argument raised by appellant, contrary to the awarding of fees, is that this is what Brian Culliss wanted as trustee beneficiary, So because this result gave Brian Culliss what he wanted, you can't pay the fees out of the trust or award them from the other side. Essentially, what this rule would state are two arguments. One, this is really just a relitigation of the self-dealing claim. If the court finds this transaction to have been self-dealing by Brian Culliss, contrary to the arguments I've made previously, then yes, the appellant is correct. Fees cannot be awarded because the court would have ruled against Brian Culliss on the substance of the matter. However, if on the substance, the court rejects the self-dealing argument and affirms the district court's decision, then there is no self-dealing. And there is no unauthorized self-dealing, which would negate appellant's entire argument against the awarding of fees.
Mr. King, may I ask you a question, please?
Absolutely.
In the exercise of its discretion, could the court have apportioned fees between the two brothers?
Yes, it could have.
50-50, 60-40, taken all of the fees together and then divided them in half, any of those ways?
The court has great discretion in allocating the fees between the parties and the trust. And so everything you proposed, Your Honor, I believe Kansas law authorizes.
And it didn't have to be winner take all.
It did not.
In terms of fees, I'm talking about. It
Correct.
did not have to be, because, and is it your view that the court had the discretion to say, yeah, the trust should pay all of the attorney's fees?
That is correct. I believe the court had that discretion.
Okay. Thank you.
And the last point, Your Honors, I would make on that is the rule that the appellant is effectively asking the court to apply, which is anytime a trustee beneficiary gets its way in the distribution of assets in a case, they can't recover their fees because it benefits the trustee beneficiary. If that rule is applied effectively for the thousands and thousands of Kansas trusts where mom and dad had one of their kids serve as beneficiary, that would effectively preclude the award of fees ever in those cases. And that will apply to thousands of small family trusts, just like this one across the state, contrary to, in this case, the express will communicated by the grantor through the attorney fee provisions of the trust. You know, as I have happy to stand for any other questions. Thank you, Your Honor.
Thank you, counsel. Mr. Ong, you have 7 minutes.
I think one of the key factors is, in this case, is the appellee's assertion that the non-pro rata language occurring later in the trust, in the context of all apparently standard trust provisions, the rule against perpetuities, spendthrift clauses, accounting actions, that somehow can be pulled out and can govern the distribution of the land, the main assets. In the Shorts v. Barker case, the panel said it's really a strain to read what otherwise appears to be boilerplate language as overriding a fundamental right. And I think this is a strained reading too, that two words buried deep in the trust document govern the distribution of the land, when the language expressly applying the distribution of the trust says divide equally among the two children. What that strained reading also would do is it completely avoids and negates the provision of the trust in Article 8 that is said the grantor's primary intent, which is the trust shall be administered to, quote, the best advantage of the beneficiaries, then entitled to enjoy the benefits thereof. That would seem to be however the trustee administers the trust, the primary intent of the grantor is that be done to the best advantage of the beneficiaries, which can only mean Brian Culliss can't give an advantage to himself. He doesn't also give to Gary Culliss. Either the clause means something or it does not, and it's in the trust for a purpose, and that must mean, and to say that the non-pro-rata clause overrides not only the distribute the trust equally, but also overrides the best advantage clause is, I think, basically using the language of the Schartz v. Barker as very strained reading of a fundamental duty.
Mr. Ong, would you, I have one question about this if I could.
Mm-hmm.
Would you have us just ignore that? I mean, I suppose we could label it as boilerplate, but should courts ignore language that are in these types of documents?
Oh, I think, Your Honor, I think the court's duty is to read the document as a whole, read the entire document as a whole, and make make its judgment not upon one specific language, but reading all the clauses together, giving them all weight. And when we have a clause labeled distribution that says divide equally, we have a clause at the end that says the primary intent is for the best advantage of the beneficiaries. Those two clauses read in the same document as the non-proratic clause. Well, let me give you an example about where the non-proratic clause comes into practical use. It's discussed in the brief. In the briefs, a couple of assets in this trust are, other than the land and the cash, are a boat, a gold coin, a picture. Those aren't things that can be split 50-50. You can't tear a picture in half. You can't tear a boat in half. I suppose you could melt the coin and split the contents. But land, when a fiduciary in Kansas has land and a group of beneficiaries to be distributed, we all know it gets distributed tenants in common unless the beneficiaries agree otherwise. Land is infinitely divisible by the parties. And again, Julia Culliss could have provided otherwise for land, but if the beneficiaries don't agree on land, and we all know this from intestate estate or wills, if the land's not sold and the family doesn't agree on a disposition or swapping out pieces of land, it comes out as tenants in common. And the family works throughout what they do. And that's what, in fact, our client proposed to his brother, the fiduciary. Let's co-own this like mom intended. And the non-pro-rata there is also for things like if there were beneficiaries who were neither our two parties, but say a grandchild was supposed to get $5,000, and there's one grandchild needed a car, and there was a $5,000 car valued. One grandchild could get cash, one could get the car. It just makes things work. But when the trustee himself is on both sides of the transaction, that's where 58A-802 is expressly applicable. And that's where the caution is. It's avoidable transaction unless the beneficiaries agree. This is protective of every family in the state. And as the appellee's attorney said, it would be chaos if it suggested that it would be chaos if the non-pro-rata clause was in place. I can guarantee you it would be chaos in the state if fiduciaries began to pick and choose assets of the objection of their siblings. The courts would be flooded. We all know that this isn't how estates get administered in the state. In my very brief time left on the fee issue, we have the district court judge acknowledging that my client acted in good faith. And in fact, his view about what his mother wanted may well be correct. He said that in his ruling. Nevertheless, he, for some reason, chose to award all the fees. We think that's an abuse of discretion. And then count 5 is really, I think, something is not an abuse of a discretion standard. It's a matter of law question. This unusual provision where it says any future fees, whatever they may be, are hereby allocated to Gary Culliss, and that frankly has no basis in law. We went through the a number of Kansas cases that just says that's reversible as a matter of law and not and abuse of discretion. So we would submit that on the issues related to the allocation of the land, that this matter be reversed and be remanded. And then on the fee issue, as actually Judge Hill noted, the court could allocate administrative costs to the trust. And in fact, we agree there are some costs that are necessary to course of administration. We agree to that. The other cost for people acting for their own benefit, whether it's to allocate the land to themselves or allocate it at a lower value, that's not a necessary and appropriate expensive trust administration. That's acting for your own account. And we'd ask that those findings of the district court be reversed as well. Thank you.
Thank you to both counsel. We will take the case under advisement and get you our written decision when we can.
Thank you.